This is The Briefing, a podcast presented by Mussio Goodman Law Firm.
The topic today is when a person lacks mental capacity, and we're here with Wes Mussio, the managing partner at the law firm of Mussio Goodman.
Thank you.
When does someone have a lack of mental capacity?
I mean, that's a tough question because we all have seen, ailing older family members losing their cognition a bit. But if you look at whether or not somebody has mild dementia or Alzheimer's, it's not enough. They actually have to be very mentally unwell in the sense that they don't understand what they're doing, and also they don't understand the nature of their consequences of what they're doing. So that's basically, the general definition of lack of mental capacity in British Columbia.
What can I do if my family member lacks capacity?
Well, the first thing I'm going to tell everyone is that when you're dealing with an aging population, as we are in British Columbia, you should be bringing off your elder mother, dad, friend, whatnot, to a lawyer to get a power of attorney done in a living will, because that will save everyone a ton of money, because all it is a few $100s for those documents. And what they do is they show, they allow, if you become incapacitated, it allows somebody to step in and take over your affairs without going to court. Now, if you didn't take on that early event and get the paperwork done, the next thing what you have to do is you have to go to court and do a comiteeship, which is very complex, expensive, but is something that you'd have to do in order to gain control over the individual that no longer has mental capacity.
What does this type of application require?
Well, the comity application isn't easy to do, so you have to have a series of affidavits. Two of them have to be from medical doctors saying that the individual doesn't have mental capacity. And then you also have to have an extensive affidavit showing the affairs of this individual, like where are they living now, what are their assets, who are their family members, and why are you the one that should take over all of this. And then you also have to serve the individual that's got no capacity with the application so that they are aware that somebody's trying to take over their financial affairs. So it is a rather complex thing, and it's a fairly expensive endeavor, especially when you have to get two experts to jump in and tell their opinion. But these things are not overly complex if they're not fought. But unfortunately, a lot of times when there's a comiteeship that's being sought by one family member, the brother or sister will jump in and want to do it, and then you're into a big battle as to who's the best person for it.
That sounds expensive and complicated.
It is.
Is there any other approach?
Well, like I said, the other approach would be doing the paperwork before the person becomes mentally incapacitated, and that would be simply the power of attorney or the living will, or the living will. And if you get those involved, then it makes things so much easier, because otherwise, if you don't, then the other alternative, if you don't go for a comiteeship, the public trustee can take over the affairs of the individual and or somebody, a third party that you don't really particularly like your brother or sister. And if you have any further questions on this topic or others, feel free to reach out to me at my email, mussio@mussiogoodman.com, or give me a call at 604-336-8002.